We've read the briefs, ready to see who you are. I would normally start you regarding reserving 5 minutes for rebuttal, but I guess at this point we'll see if you need to reserve any time.
I'll reserve making that decision on whether I need time for rebuttal. My name is Ben Miller. I represent Nicole Lingenfelter. She now goes by Sorensen in the matters before the court. I was not the original trial attorney. I was retained by Nicole after trial of this matter to prepare objections on her behalf. After preparing the objections, we requested a transcript of the proceedings. Proceedings occurred over 2 separate days. It was at that time the transcript disclosed that at the end of the first day's hearing, the magistrate asked to speak with both counsel for Nicole and Jason, and disclosed that he had known Jason's parents for a period of 35 years, and that a former secretary of his was the cousin of Jason, the niece to one of Jason's parents, I believe the mother in that case. But there's nothing in the record that indicates that that was ever disclosed directly to Nicole. And it's not clear from the record why the magistrate said, you should know this. If the magistrate believed it was necessary that the parties be informed of this, it's unclear as to why the magistrate decided to wait until after the first day of trial to, in fact, disclose this relationship. All of the assignments bear in this case are reviewed by the abuse of discretion standard.
I apologize, I'm stepping in.
I understand. Would you like to reserve any time for rebuttal?
Yes, Your Honor, I reserve 5 minutes for rebuttal. May I continue? Thank you. So it's not clear as to why this wasn't disclosed prior to the hearing. I know that Jason's attorney brief indicates, well, maybe he didn't realize before then, but I think the inference is if you've known someone's a couple for 35 years, you would be aware that they have kids and that who that child is in fact is. In any event, there is no objection put on prior to the start of the second hearing. The matter proceeded. A decision issued, and under the Judicial Code of Conduct, which applies to magistrates as well, anytime there could even be the appearance of impropriety, it's mandatory that the rule says shall recuse himself or herself. If one reads the decision that was issued by the magistrate, only 2 people testified at the trial, Jason and Nicole. If you read through the magistrate's decision, every decision that could have been gone one way or the other was phrased in such a way where the magistrate took Jason's version. There's a number of examples of that. The magistrate indicated that Nicole hadn't done a good job trying to find work. And my review of the record didn't show that there's testimony from the 2 parties, and Nicole testified that she had been ongoing looking for work.
If you don't mind, could I have your attention to a couple things and I have questions?
Absolutely.
I'm most interested in assignment of error 3 and 4 dealing with the blank and non-stop enforcement. The board will actually be naming mom as outdoor and is there a dollar now?
Your Honor, it's very troubling. When you read this whole decision, basically, Jason walks away with the money available to service all the debt that's in his name or the joint names. There's a shared parenting plan that envisions equal time for both these parents. Spousal support was awarded an amount of a total of $1,800, $300 a month for 6 months.
We have how much, $30,000 we have to pay for that?
He was assigned like $30,000 marital debt. She was assigned like $3,300. I think it's around $13,000 that the magistrate said, well, this can be considered in lieu of a lump sum amount for spousal support. But it doesn't leave Nicole in a position, especially with his decision with respect to child support, that she was in fact the obligor, even though her income, even as considered imputed, is well under what Jason's is. She's in a situation where she's supposed to have these kids at equal time, and she hasn't worked since February 2012. There's nothing in the record that indicates, other than Jason opining, that contradicts Nicole, indicating that, hey, I've been trying to get work. There's no evidence in the record to show that there were jobs available for her, that she was turning down. So it puts her in a position where she really didn't have any funds available to maintain these kids. And I don't believe that that's in the children's best interest. The magistrate, it appeared to me, decided that my client Nicole should be the obligor because he was trying to make sure that there would be enough money that Jason could cover his debts. And I think given the relative earning abilities of both these parties, the court erred in naming Nicole the obligor in this case. I wasn't able to find any case law directly dealing with that issue of who should be the obligor or who shouldn't be the obligor, but I believe that the framework of the system would indicate that if there's one party with substantially more income than the other party, there should be income flowing to the party with the lesser income.
You mean like the 50/50 split?
Yes.
Well, I thought, and perhaps I misread this, I thought that the reason why the court took this approach was because the husband indicated that wife was not paying bills and had hidden or misplaced, I can't recall the language, certain bills, and the court credited his testimony in that regard and didn't want to put him in a position where his credit would be affected by the way that she handled money.
There was testimony, and there's testimony in the record that there were 2 or 3 bills that were misplaced or hidden, however you want to characterize that. But another thing that I believe the court was looking to when they made the decision on child support, there was testimony in the record regarding, well, Jason didn't believe that would be going to the benefit of the children, and I don't think that's a proper reason to name one parent the obligor or not. I think we assume, presumption is that money going to another parent in the form of support is being used to support the children. And support obviously is much broader. It's having a place to live, it's having food on the table, it's being able to access clothes, being able to provide transportation, all those types of things. So I believe that in this case, even if the court would assume that, okay, because of the relative incomes here and the division of debt, spousal support is reasonable. I don't think the court can find that naming Nicole the obligor was reasonable in this case. I think it was an abuse of discretion to name her the obligor in this case. Not having been the trial counsel, I had the benefit of looking at the magistrate's decision with fresh eyes, and I was just struck by the tone of the decision with respect to crediting Jason at every turn over Nicole. And you have to put yourself in the position of Nicole, who later finds out there's a 35-year relationship between Jason's parents and the magistrate who's hearing this, and every decision that could have gone one way or the other went against me, essentially. So she's left with $1,800 in spousal support. Sure, she doesn't have to service that debt, but she's not even given anything with respect to support, child support, to attempt to provide for her children. I mean, she's been put in a position where she's relying on others to do that.
And you were just now reaching your 5 minutes or about, you may continue on this resolution.
Thank you, Your Honor.
Good afternoon, my name is Roseanne Schreiner. I represent Mr. Lingenfelter in this matter, who is the applicant. I think I entered the courtroom in the middle of the appellant's argument. I would like to address a couple of things that I did hear him talk about. First of all, with regard to disqualifying the magistrate. With regard to this issue, Magistrate Hines stated on the record when attorneys were in the courtroom that he was familiar with the parents of Mr. Lingenfelter. However, he didn't say that there had been a relationship between them. It was pointed out that they're from Holmes County, everybody in Holmes County, because it's such a small county, knows each other. And the magistrate indicated that this was not going to hinder his ability to make a fair assessment of the case.
And does this happen before the case starts? Does this happen after the case is heard but before a decision is made?
Actually, in the middle of the case, we were there on one day and started the process, the trial. We were not able to conclude the trial during that first day. It started late. He, during that trial, the first part of the trial, realized who the parents of Mr. Lingenfelter were. He then kept the attorneys after that first day and spoke to them about the fact that he did know of these people and he was aware of who they were.
So when you say he kept the attorneys, he realizes during the time the evidence is being put on, allows the case to continue, and then brings the attorneys in with him and dismisses the parties? How's that?
Asked for the attorneys to stick around so that he could talk to them briefly, and had other issues that he wanted to talk to them about with regard to seeing if we could settle this matter. And again, it wasn't concluded, the trial had not been concluded, and we all knew we were coming back for a second day. So there was probably, I don't recall the exact time, but there was a long lapse in between our first day of trial and our second day of trial. I want to say it was probably about 3 months from the first day to the second day. Plenty of time for Ms. Lingenfelter to have a problem with this magistrate and say, listen, I think he has a conflict. I need him to be disqualified.
That's assuming that counsel relayed to her what he or she had heard, what was told.
Correct, but my understanding of the case law is that when notice is given to an attorney, it is assumed that it also goes to the party that they represent. And I haven't seen anything with regard to the appeal that Ms. Lingenfelter filed stating that she had ineffective assistance of counsel. So if that had not gone to her, that information, I certainly would have thought that that would have been an assignment of error that she brought forth before.
That is clear, not practice.
It could be, but if you're here arguing that this magistrate was disqualified or should be disqualified and saying, well, I didn't have proper notice of it, then I would hope that you would include in your brief that there's an ineffective assistance of counsel who didn't give you that information.
And that would be a record anyway, so that would be hard to record.
Whether that information had been conveyed,
So
absolutely.
you just have to look at the things. That's all I'm saying.
I understand. In any event, we look at decisions from a magistrate and ultimately the trial court, and we look at the person who's hearing the testimony as to the person who is the best judge of character and credibility. Based on the evidence that was presented and the testimony of the parties, who were the only people who presented testimony in this case, the court made a determination as to the credibility of the parties. Mr. Lingenfelter and his statements were found to be credible. They were backed up by appropriate evidence, and the court took his version of issues or arguments for the most part, not all of them. There was an issue with regard to an alleged domestic violence situation in which Mr. Lingenfelter sustained some medical injuries and incurred costs associated with those medical injuries. He asked for those to be the separate medical bills or separate debts of Ms. Lingenfelter. The court denied that request. In fact, he asked for the debt to be split more equally between the parties. The court ignored that request. The court gave him $30,813 of marital debt, while giving Ms. Lingenfelter $3,300 of marital debt. So certainly not an equal division of the liabilities or marital liabilities.
No, but, and I don't know exactly what kind of marital debt is, but, with debt, you should have an ability to pay it off over time. And you can file bankruptcy, you can do a lot of different things with debt. But if the debt then is counted against your spouse's support, then, let's say they divide the debt equally, and then order, $1,000 a month of child support. Not child support, spouse support, just as a hypothetical. She might have had the option of, like I said, either filing bankruptcy, or she might have the option of renegotiating with the creditors. There could have been any number of things. Now, some of it may have been marital debt, there might have been other limitations. Not marital debt, I don't know how it all worked out. There might have been some things that you couldn't have done some of that with. I don't know.
And that's what my response was going to be. Many of these debts were in their joint names. And so to have a situation where she could possibly file bankruptcy by giving her the debt, then that's going to ruin my client's credit and affect him.
But were all of them in both of them?
Not all of them, but some of them, and the larger ones were. So to that end, I believe what the magistrate was doing was trying to protect the credit of the person as part of the parties, as part of the allocation of the debt. And he also used that as a reason as to why she received the amount of spousal support she received, because as part of those factors that we can consider, the allocation of liabilities and assets is to be considered, and that is one of them. And the $30,000 was for the most part unsecured debt. That didn't include the mortgage that he took on or anything of that nature. With regard to that, he did get the house, yes, and there was a very small amount of equity as part of that house. Additionally, Ms. Lingenfelter lived free of any expenses for over a year. While she was in the marital home, he paid for all of the expenses, the mortgage, the utility, car payments, expenses, everything. She had absolutely no expenses for over a year. So the court also considered that in making their decision regarding spousal support. She was not working, but again, our argument was that that was by her choice not to work.
Now, what was the evidence against that? She said that she had tried to find work but couldn't?
I don't recall her stating that she had tried to find work all that much. She indicated that she put a couple of job applications out there. As I recall, she couldn't give specifics and had no evidence of that to present. There had been a history of her having jobs and then walking out of jobs on her own or being fired for cause. So our argument was that had she attempted to find work and stuck with that work, then she could have been fully employed. She did have a history of work prior in the insurance business, and I believe, if I'm remembering correctly, she was also able to find employment at the Child Support Enforcement Agency. Both of those were decent jobs. She should have been able to make a decent wage with regard to those. With regard to my client being named the obligee versus the obligor of the child support obligation, my understanding as to why this occurred was in the request by my client to have the allocation of expenses for the children. Unlike most shared parenting plans where we're doing a 50-50 split of those costs associated with the children, my client offered to pay 100% of those costs. And he was asking for that because there had been a history of his wife at the time hiding bills, not paying bills, presenting a grocery bag full of bills to him at once. And his take was, when those concerned the children, he certainly wasn't going to let his children go without. So if he was paying child support on top of paying for these expenses, it would be a windfall for him.
what do you mean by 100% of the cost? So 100% of the cost would be housing, transportation, food.
The magistrate set those out in his decision and called them extra costs.
So it wasn't just cost, it was extra.
It was the extra things. Housing, utilities, those were innate costs that the court didn't include in them.
Because both parents have to have a house for the children, especially
Correct.
shared parenting.
Correct. So what the court was looking at was those extra costs, and instead of splitting those between the two parties, made Mr. Lingenfelter 100% responsible for them. And Mr. Lingenfelter asked for that, he knew of the responsibility associated with that and had no objection to that. I believe that that was also why the court then made him the obligee, because he was the one paying all of those expenses.
Well, but the felon's argument is, I still have to be able to maintain a residence, put food on the table. I should be able, the case law usually says, is to provide the same type of environment for the children in both homes.
And what Mr. Lingenfelter's argument was with regard to that was she had that ability had she taken advantage of it. But through her own voluntary underemployment or unemployment in this case, she chose not to work full-time. She chose not to go out and put in job applications like somebody in her position would in normal
So
circumstances.
let's say she's bringing $24,000 a year. What was the amount? 50 something? I can't remember. I think actually I figured out in, I don't know.
56,000.
56?
Yes. And she was receiving,
Over 2 times.
well, but she did receive a spousal support award of $3,600.
6 times 300?
I think that there was credit given for prior payment.
So 3,600 altogether.
Yes.
That's not 3,600 for a period of time or anything.
3,600 for a year is what the court placed in their child support calculation.
And this is a marriage of 13 years or thereabouts.
Thereabouts, yes. But also in consideration of that is the fact that they may not have had equal incomes, but my client was paying all those extra expenses associated with the children. So that's not something we see when we're looking at a dollar-for-dollar comparison in wages.
I've never seen a case though where you say, I don't think mom can handle the money, so we're not going to give her child support.
Well, I don't think that the court exactly took that, I mean, they did
I think
say,
that's what your argument was, isn't it? Because I was reading it in your brief.
our argument was that my client would take 100% of the expenses associated with the children, those extra expenses, because he wanted to make sure they were paid.
Like, give me an example. I know it's in the order, but just tell me.
Extracurricular activities. Any extracurricular activities that the children are involved in, all costs associated with them go to my client.
And that would be determined between the both of them as to what they're engaged in, because it's a shared parenting.
Correct, yes.
What else?
What else was included in that? Give me a second, I can look at the order.
Extracurriculars. I don't know. I'm just curious because I'm trying to see that in action. Usually I would take up the time, but I want to see in regards to your argument.
Sure.
While you're here physically.
The court stated that his costs in raising the children will be higher than defendants because of the costs associated with him covering the children, the unfixed costs. Those would include cost of food for the children, entertainment. I'm sorry, that would be the fixed cost. The extra cost would be the school fees, school lunches, cell phone charges, vehicles, vehicle insurance, clothes, and fees and expenses related to the sports.
That's page 14.
Okay, so
And in addition to that, he is paying 71% of the health insurance expenses, the uninsured. And he also covered the children on his health insurance.
Thank you for looking at that. Before you launch.
I'll just close by asking the court to overrule the assignments of errors that have been presented to it by the appellant. Thank you.
Thank you. There's quite a bit of discussion regarding what Nicole was doing as far as working, and the party stipulated that she was primarily a stay-at-home mom and was primarily responsible for child care, and Jason was the primary breadwinner. That appears in the transcript on page 126. Nicole also testified that her last position was with Western Southern Insurance, page 126 of the transcript, that she worked there on a salary for about 6 weeks. It sounds like she had to draw, and she had to be generating enough commission income to get paid, and she wasn't doing that. She testified that she was actually losing money at that position.
So you're saying, was it an oral stipulation or a stipulation that her chief primary carrier?
I thought that appeared in the stipulations.
That's fine, we'll find. Thanks.
If they're not in, I would apologize, Your Honor. Nicole also testified that she worked at J. Michael's as a customer service rep between 2003 and 2007. She made $10.58 an hour. She worked at Graphic Publications from 2008 to 2009 until she was laid off. After being laid off, she went to the Career Center. She got a certification as a pharmaceutical tech. When asked by her counsel what's the most she ever made, she said about $10.50 to $11 an hour. Nicole testified at trial that since leaving her position at Western Southern, she would continue to put out resumes and applications on a regular basis. And according to Jason, Nicole told him that she was continuing to look for work. In my review of the record, I didn't see anything else that indicated that she was not trying to look for work that appears in the record any place. As to knowledge, I mean, there's no evidence in the record as to knowledge with respect to the relationship between the magistrate and Jason's family. There's probably, in hindsight, I'm sure that the magistrate would have preferred that, hey, I probably should put something on the record before this whole thing got started. I'm not clear as to why that didn't happen in this case. This case went on for a long period of time. The magistrate, I assume, had knowledge of this relationship throughout at least most of that time. Lingenfelter is not the most common name. I think the appropriate thing for the magistrate to do would be to say, hey, listen, this is the relationship I have with these people. I've known his parents for 35 years. His cousin was my secretary for a period of time when I was judge. Why don't you go either bring the clients in so I can disclose it on the record, which I think would have been the preferable thing to do, or talk to your clients about this and let me know whether or not there's any problem with this. If this whole conversation is actually on the record, it's in the transcript. And it's in the transcript, the magistrate said, I mean, I know his mom and dad, by the way, just so you know that, I know Dave and Alice Lingenfelter. I've known them for 35 years. In fact, I know my secretary is the niece of Alice. And when you find out about those statements after the trial is over and after there's a decision that really does not go in your favor at all, and you see a variety of comments that is in the transcript as well, the magistrate said when with respect to testimony regarding a physical altercation between Nicole and Jason. What were her injuries? Broken hand from hitting him or hitting? Magistrate also said spousal support. I'm not impressed with her. I really am not. I mean, she should have been out beating bricks, getting a job for the last year or so. I think you know that. There's nothing on the record that indicated that she wasn't doing that, that she wasn't actively looking for work. When you're looking at this case, and that's the context, and you have a situation where there's no stream of income coming to this person that's been unemployed since February of 2012, there is an appearance of impropriety with respect to that.
Was there any testimony at all about the job situation in this area during the time that the
I
magistrate?
don't believe so. I don't believe there's any testimony regarding that. So it was really just Nicole's testimony and Jason's opinion of that.
Council, you have reached the end of your allotted time.
Thank you very much, Your Honor. I'm going to ask you to send this back to the trial court for your evidentiary hearing.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision